Good morning. It is just before midday on the Friday the 11th of December 2020 with just under 3 weeks until this year is finally over. My name is Aaron Hunt, I'm a partner here at Stays Hammond and I head up the Migration Partners team. Now as always, this is just our comments on immigration in New Zealand and should not be taken as being legal advice. If you're looking for legal advice, please get in contact with us by email or by phone and we'll see how we can help you out. Now as I mentioned in the comments too on the YouTube website, the forum, that it's been a quiet 2 weeks for immigration news in New Zealand. There's been a few small changes that will impact a very few number of people and really not enough news themselves to make a video. So we want to make sure that you hopefully get some sort of value out of our videos and not just doing a video for the sake of having another video. So we're going to run through those recent announcements pretty quickly and then we're going to go on to go through some answers to a few of the questions that people in the comments have asked us about and asked us to comment on in our videos, as well as provide a little bit of news that may have an impact on a number of you. Now we'll leave the start times to each of the sections in the description, so if you want to jump to a certain section you can without having to watch the entire thing. So first we're going to touch quickly on the changes that have been announced in the last week or two. Immigration New Zealand and the government, just so you know how this works, because the government are the ones that ultimately decide what the rules are going to be. Now they usually release updates in two ways. So big updates will come through a press release on the Beehive website. So for those of you outside New Zealand, the Beehive is the name given to the New Zealand Parliament building because it looks like a beehive from a children's book like Winnie the Pooh, that sort of beehive shape. Now we haven't seen any Beehive releases on immigration in a little while. The other way we get updates is from Immigration New Zealand themselves, called amendment circulars. Now these notify us to changes in the operational manual, which of course is the rules that Immigration New Zealand should be applying. We've had 3 of those in the past week or so, so we're going to quickly just go through those. Now the first of those is that halal slaughterers, who would have otherwise been subject to a stand-down period if they've done 3 years of visas, and can now apply for a further 6-month work visa between 1 January 2021 and 30 January 2021. To allow them to stay in New Zealand a little bit longer. The second is that they are allowing for 60 sheep shearers to get a border exception to come into New Zealand as long as they arrive before 31st of March 2021, have employment with a NZSCA, isn't that some sort of sheep shearing society or association, approved employer, and have at least 2 years of shearing experience. Now, as the Managed Isolation and Quarantine Facilities, or MIQ, is currently booked until late February, applying now and arriving by 31st of March could be difficult. Now, the third change is that SSE work visa holders, which these are the Supplementary Seasonal Employment Visa holders, which was granted to working holiday visa holders to allow them to remain in the country and pick fruit, will not need to provide a medical certificate, X-ray certificates or police certificates unless the immigration officer believes that there's an issue and they need to provide those documents. So nothing really groundbreaking. It could be good news for you if you are a sheep shearer, but if you are, then move very, very quickly because that 30th of March time frame is pretty tight with MIQ being so full. Now we're going to answer some of the questions that people have asked for us to include in a video. There's about 3 or 4 I think. We're going to go through them one at a time, and of course we'll link to the times below in the description if you want to jump to a certain section. First one is in regards to Naveen asked about essential skill work visa holders who have or may have their hours reduced. Now Immigration New Zealand defines full-time work as being 30 hours per week or more. So for essential skilled workers, this is in W210 of the operational manual. Now if we refer to any point to a letter and then some numbers, that's us referring to the operational manual, which is the rules immigration is supposed to apply. So for essential skills work visa holders, that's W2.2.10 or W2.210. So if hours are reduced from the more usual sort of 40 hours to an amount that is still 30 hours or more, then it will still be classified as full-time and meet the requirement of full-time employment for your essential skills work visa. Now if it goes below 30 hours, then it may come down to how long it's going to go below 30 hours for. Now during the lockdown, New Zealand were very understanding that some jobs may be temporarily reduced due to the lockdown. There was no official rule, but they did tell us that they would look at it on a case-by-case basis So even if the reduction was going to last more than the lockdown period, Immigration New Zealand wouldn't just automatically cancel the visa. They'd look at it and go, okay, when's it going to restart? Look at the circumstances. They were actually pretty understanding, as they are in most situations, to the bigger picture. They're not sort of sticking hard and fast to the rule. However, now, if that reduction to below 30 hours is going to be extended or is going to become permanent, then that will likely put the visa in jeopardy, as the conditions of the visa are not being met, that you have that full-time employment, which is 30 hours or more, and it won't be met going forward. Now, for clients where that was a possibility, we've in the past encouraged them to talk to their employers, so the employers are aware of the situation, and generally the employers have been understanding and sort of have helped them keep at that 30 hours requirement. Otherwise, immigration should really be notified, and it is a fundamental change to the circumstances. And then you're looking at possibly, you look at a variation of conditions to a new job if you can find a new job. That's often the quick way out. If a variation can't be sought, then it could be an application for a new essential skills work visa for the new job if you can find a new job, with all the usual requirements that the visa requires, including advertising by the employer, that sort of thing. Now, if you can find a new job to replace the current one. Now, if a new job can't be found, then an option is to seek, say, a visitor visa to remain in New Zealand while a new job is looked for, or to allow you to prepare to leave New Zealand. Immigration New Zealand have, again, been pretty understanding to those who have lost their jobs during the pandemic, and accommodating, and being very accommodating in granting of visas to allow several months further stay in New Zealand to allow people to look for a new job or to get their things ready to leave the country. The longer you have been here probably will depend, might give you a longer visitor visa period, but generally we're sort of seeing several months has been relatively standard. Now, the reason why we do recommend that Immigration New Zealand is notified, beyond that it is a requirement under the operational manual to notify them of a change of that magnitude, is that if someone's work hours were to be reduced, then the pay and the tax being paid to them, or to IRD for them, would also be reduced. And this would be reflected in the Inland Revenue Department's tax records, the IRD tax records. Now, Immigration New Zealand will often ask for IRD records, often going back years. Now, when you're doing an application for, it could be for essential skills work visa or for residency. We see it with both. Now, if they saw a reduction in pay, it wouldn't be hard for them to quickly calculate that someone wasn't working the required 30 hours per week, because they would have your employment agreement on file. They know what your pay was. They'd look at their pay and go, okay, divide by 30 and see whether things have changed. At that point, they will see a visa holder who was not complying with their visa because they weren't doing the 30 hours a week, and that would make future applications difficult, as the visa holder had been aware of the change of circumstances and hadn't notified Immigration New Zealand. We always encourage clients to be honest with Immigration New Zealand. It's much easier to go to them with an issue and a solution than to later on try and beg forgiveness if you haven't gone and told them what was going on. So that's the sort of the approach we take, is always about honesty with immigration and sort of providing them with a solution yourselves. Now, there is one situation we do need to mention where a drop in hours, but still above 30 hours, may still be an issue for an application. So as I said before, if you're below 30 hours, you're not meeting the criteria. If you get your hours dropped, but you're still above 30 hours, and you're on a work visa, but you have a dependent on a student visa, then you must maintain an income, the minimum income threshold. Now, this is currently $43,322.76 per annum. Now, someone working at the $25.50 per hour, which is that requirement you have currently for the 3-year work visas, someone working at that amount for 30 hours per week would only be on $39,780 per annum. Actually, so actually $3,500, $4,000 below that threshold. And they would not be eligible to support having a child with a student visa. So if you are on a work visa and you have a child on a student visa, you need to maintain the annual income above that threshold. Now, you can see more about this in U8 25.5, which I'll link to in the description below, so you can see more about what the requirements are there. But that is something to watch out for, so you don't get caught out by thinking, well, you're above 30 hours, you'll be fine. Well, you might not be, so definitely keep an eye on that. Now, next set question was Ninu asked about phone interviews that Immigration New Zealand may want to do with offshore applications for partnership applications, which would include CPVV, which aren't actually sort of partnership visas, but they still will often require an interview. Now, Immigration New Zealand has, over the years, had to deal with a number of fake applications, from people who weren't being honest. For that reason, we've seen the rules change again and again to help block or at least restrict those applications. Now, with partnership applications, there have been people who have applied who aren't necessarily in a relationship but pretend to be in a relationship so they can come to New Zealand. With the current pandemic and New Zealand doing absolutely so well in controlling the spread, this will still be happening and possibly happening more frequently. So what it means is that there is a greater scrutiny on all these applications, as Immigration New Zealand needs to be sure that relationships are real. Now, when you apply these applications, you're putting through documentation that's being provided, and it's often enough to satisfy immigration that a relationship is real, especially for those who have had years together and have children together. That is evidence that really can't be faked, a human sitting there. But every other piece of evidence could just merely show people who flat together or who are friends, who travel together, who talk often. And documented evidence can be prepared and thought about in advance, so you can sort of doctor it in a way to show what you think immigration is going to look for, which is why Immigration New Zealand won't just look at it and go, well, this must be genuine. So one way to help immigration to find out when things are genuine and when they're not is to conduct telephone interviews. Now, these allow Immigration New Zealand to look at things that aren't mentioned in the evidence. So they won't ask you about the evidence because the evidence you've already provided, so you're already aware of what's in it. They'll ask you for things outside of it. So they'll look at questions that a true couple would know, but people who are faking it, a relationship, wouldn't. Now, what questions are asked will differ from call to call so that people can't prepare. So there's not sort of a list of questions they're going to ask. But sort of some examples, it could be about the other partner's favourite things or dislikes or habits or perhaps their schedule of their life. It could be questions about a particular time period, such as a recent meal, what you ate, or what the couple were doing on a certain day. What were your plans on last Saturday? What were you doing on that day? That sort of thing. Could be questions about a common area, such as a bedroom, and what items are in it, who hangs up their clothing on what side of the wardrobe, that sort of thing. It could really be anything. And Immigration New Zealand will often call both partners at the same time, so that you can't discuss what the answers and questions were between the two phone calls. It allows Immigration New Zealand to get a better understanding if an application is real or not. Now, one thing to remember about this is that Immigration New Zealand do not expect perfection. So don't panic when they call. Try and stay calm and just answer the questions. I've heard from many applicants, many clients, that the questions that were asked, and some of them I would have difficulty answering with my partner. You don't always know everything they're going to ask. It could honestly just be, well, no, you don't know. So, and I've been with her for 1.5 years, and we're still, over time, you learn to know more about them and how things work. So don't panic because you think that you'll. Don't panic because don't worry that you think that if you don't answer a question, they're going to think that you're faking, and then you'll panic worse about that taking place. And don't think that by panicking a little bit, they're thinking you're being dishonest. They would have done a number of these interviews over a number of years. And that some people will find answering questions, it makes them nervous. It's an unusual experience, and Immigration New Zealand know that. So if you don't know the answer, then just say that you don't know the answer, and perhaps say why you can't. Immigration New Zealand are very good at seeing when someone isn't being honest, and dishonesty is a major issue for Immigration New Zealand. So just take a breath and try to answer the question as best as you can. Next question was from Ashitha, sorry if I'm saying your name wrong, who asked about how to request a border exception. Now, we have covered this in a previous video in a lot more depth, but I will give a quick rundown here. Now, there are two kinds of border exceptions. There's those which the applicant applies for, and those which the employer applies for. Now, the employer applies for it if it is an exception based on being an other critical worker. So, and in all other cases, the employee, or the person, the applicant, applies for it, including if the applicant is coming to New Zealand as a health worker, under health worker exception. So it's just that other critical worker exception, the employer does it. For the employer form, it has its own Immigration New Zealand, a new website on the Immigration New Zealand website, which we'll link to in the description below. It needs to be completed by the employer or the employer's lawyer or immigration advisor. There are several documents that need to be uploaded with that. They're relatively simple. Once it has been uploaded, if it doesn't get rejected at the first review, the immigration officer will be allocated and will likely come back and ask for more information, ask for more documentation. That's pretty standard. It costs $380 to apply for that employer exception for the other critical worker. Now for everything else, the application is done on another page, which we'll link to below, which is done by the applicant rather than the employer. Basically you complete the form, and in doing so you're submitting what they call an expression of interest, or an EOI. Now the cost of submitting is only $45, so it's relatively cheap. If the EOI is accepted, then you will receive an invitation to apply, which is an ITA, along with a number. You then log into the usual Immigration New Zealand system to submit the actual visa application, as the EOI is just asking for permission to apply for the actual application. We'll link to the main application systems below as well, so you've got links to both the EOI page and where you do the actual application itself. You are then looking to apply for a visitor visa, being a critical purpose visitor visa, unless Immigration New Zealand instructs you otherwise. So most of them will be a CPVV, but if they say to you, no, apply for this, then follow their instructions. We're sort of looking at the very general sort of outer view here that's going to cover most of them, but there could be exceptions in there. So follow what Immigration New Zealand instructs you to do. You then supply the ITA number into the application, which allows the application to be processed. You provide the usual information for a visa, provide the necessary documentation, and then submit the actual application. The immigration officer may then come back to ask for more information, and probably will in most situations. There is one exception to the above process for the personal applicants, and that is if you state in the EOI form that you are an Australian passport holder. Now, if you do this, the form will actually change the boxes below. If you scroll down and change it and see how it changes, you'll see the different boxes and things appear. And the form actually becomes the application itself. There is no two-step process, it's a one-step process for them. For some, we have some issues with this approach, as it doesn't allow for much evidence to be provided, especially if you're going through for a partnership approach. It's only a few small fields and a little bit of text you can enter in there. We also aren't sure whether a decline to what is effectively an EOI, expression of interest, should be declared on future visa applications as being a decline, whether in New Zealand or elsewhere. Is it a declined visa application? It's only expression of interest. Is it the same thing? We're not sure on that. But this is the way it's being done for Australian citizens. Now, the CPVV that is granted, the visa visa that is granted, will generally be for 6 months or 12 months. We've seen both. It allows the person to come to New Zealand within 6 months of it being granted, though please check your visa when it's granted to make sure that these are the case. It could differ for you. This is just, again, our being very general. Depending on the basis of the border exception, you will likely need to apply for a new visa when you arrive in New Zealand. If you're coming to New Zealand as a partner of a New Zealand citizen or resident, then we believe the expectation of Immigration New Zealand is that you will apply for a work visa under partnership once you have arrived. That this isn't a requirement. Some may stay in New Zealand on the CPVV for a period and then leave, and others may look at other visa options such as a student visa or essential skills work visa. So that's just a quick rundown of the border exception process. As I said, we've done a video previously covering it in a bit more detail, but hopefully that just gives you a bit more help on how that works. Now, Pam asked us about the second and subsequent residence visas, and I'm really glad she did, because this raised a little issue with the operational manual, which we're quite good to find these little issues need to be fixed. Now, this was a change of how it was handled last month. Now, according to the amendment circular, which was released on 27th of November, the change was made on the 12th of November, but which it probably was actually made on that date, but there's an issue with the change itself, which we'll get to in a second. Now, some of you will know that residence visas need to be activated if they are received when the person is offshore. So the person gets the residence visa while they're in New Zealand. They can come and go from the country without requiring a border exception. They can come and go while that right to enter is still there. If the residence visa was received offshore and the person has not come into New Zealand on that residence visa, it cannot be used to cross the border. So there is no border, there is no automatic right to enter the country if the residence visa has never been used and it was granted when they were offshore. It needs to have been used at least once to enter New Zealand if you want to allow travel without a border exception requirement. However, INZ has provided extensions to those travel conditions, so those people who are stuck offshore have been granted a further time to enter the country, so that they can enter the country once the border does reopen. Now, Y330 in the operational manual is the section that covers who can travel to New Zealand without a border exception being required, and that now allows people who have previously held a residence visa in New Zealand and have now received a second and subsequent residence visa, but received that while offshore. So, as they were previously in New Zealand on a residence visa, they can travel to New Zealand on the new visa without requiring a border exception, even if that new visa that's been granted now hasn't been used to enter the country previously. However, there are some conditions, and this is where the error comes in. The person must have had their previous residence visa expire between 2nd of February and 11th September, had previously been in New Zealand as a resident, but were outside New Zealand on the 11th of September, and have received an SSR by special direction on 11th September. If that's the case, then they're considered to hold an SSRV and are able to enter New Zealand without requiring a border exception. This is something that's unusual here. Now, special direction is put in place, something that's put in place by the Minister, and it's published in the Gazette. The Gazette is a sort of a parliamentary, a government publication where any important declarations are made. If it's wanting to liquidate a bankrupt a company or liquidate something, it goes into there. New changes like this, it goes into there. The Gazette's where basically lawyers go to check on official statements. There was a special direction on 11th September, as stated in the change under the amendment circular. It was made by the Honourable Chris Fafoy, the Minister of Immigration, and we've linked to it below. However, that special direction does not mention residence visas of any type. It was actually there to extend visitor visas. So we looked into it a bit further and went through the Gazette, all the various immigration releases in the Gazette, and we tracked down the 21st of September, which we'll also link to below. Now, this direction provides that any person who formerly held a residence visa and whose residence visa expired between 2nd of February and 21 September, not 11th as it says in the operational manual, and is outside New Zealand on 21st of September, again not 11th September, will be granted a 12-month multiple entry residence visa allowing them to return to New Zealand. Now, I've checked the operational manual, it still says 11th September, so there's an error in the operational manual, which is surprising that it's still in there. So nobody at Immigration New Zealand has noticed that yet. So thanks to Pam for raising the question. So generally speaking, it's if you had a residence visa, you were outside the country between February 2 and 21 September, you'd used that residence visa to be in the country previously, then the Gazette, under the Gazette, the special direction, you've now been granted a further 1-year residence visa, multiple entry, to come back into the country to allow you to return to New Zealand, which is fantastic news. Now, that's sort of the questions that we were asked, we sort of answered. There is one thing we do get often asked about, and that is exceptions that fall outside the border exception allowances. So situations where people are seeking a border exception but don't quite fit into the current exceptions that exist. These are often the hardest questions to answer, as exceptions to the border exceptions are very rare and very hard to get. So far we've been involved in just one successful exception to border exception rules. We haven't actually applied for many, but actually very few, because they are generally so hard to get. And I try to be honest with clients and just say, look, it's highly unlikely that you will get this, and for the reasons why we're about to go through. We cannot imagine the difficulty that many of you are going through. Being away from family, separated from family, from your partners, from your children, away from unwell family, unwell parents, children, siblings, separated by the border closures. However, and we say this just to try and be honest with you, you are not alone. There are many people in that same situation, and it makes an exception on those grounds practically impossible. As hard as they are, and this is the reasons why is that there's generally 3 areas we can argue an exception to the border exceptions on. There's compelling personal circumstances, humanitarian grounds, and matters of national interest. Now, humanitarian is an extremely high threshold, and under the Immigration Act only applies to those who are within New Zealand where the Act allows for humanitarian reasons to prevent deportation. Using it to enter the country is not something we have seen. No, it's not sort of an allowance under the Immigration Act. Now, compelling personal circumstances are possible, and the one we have seen, that was one of the grounds, but it was combined also with matters of national interest. So that application was sort of two things in one as to the grounds that they were seeking the exception. The personal circumstances were not for the person offshore, but the partner in New Zealand, the New Zealand citizen in this case. And that would usually be the focus on any application for an exception to the rules, would be on that New Zealand, the person in New Zealand. That's the person that immigration are actually looking at the most and caring about the most, and that's just the truth of how it works. National interest is more difficult, but we'll be looking for something that showed a significant benefit to New Zealand, either financially or in relation to the health of New Zealanders. And that is why these are sort of very difficult thresholds to reach. Where we often explain it to people is that if Immigration New Zealand was to provide an exception to the rules for their situation, how many other people would fit in the same situation? If it's more than just a handful, it becomes less likely there's going to be an exception that would be granted, because if immigration provided for that one person, they'll provide it to the many, many people, and they would swamp MIQ. Now, as much as we want MIQ capacity added and increased, I NZ keep it at the same level, and that to make sure there's still space there for New Zealanders to come home. So an exception to the border exception rules needs to be so particular and just affecting a very small number. If it impacts a large number, it's just not going to go through. That's how Immigration New Zealand are handling these things. There was one last thing to discuss we wanted to sort of raise today, and that was, again, we've been through it a number of times before, about MIQ space, because that is a major factor as to who can come into the country and when we'll see further border exceptions made. MIQ is still booked 2.5 months in advance, so as of this morning I checked, and the next available dates are sort of things like 25th of February. So we're still seeing long delays in people who want to come to the country or have a right to come to the country having to book that isolation months in advance. What this means is that Immigration New Zealand is unlikely to grant new border exceptions, as it would just further swamp those facilities. Our great hope up till recently has been that Australia-New Zealand bubble, which would mean that people travelling from Australia to New Zealand didn't need to use MIQ. Since lockdown, there's been about 40% of those people in MIQ have come from Australia. During December, it has gone down a little bit to about 33% as Kiwis from further away have been coming home. But it's still a fairly large number. You know, you're still looking at more than, well, basically 1/3 or more coming from Australia, taking up that space. So if a bubble was created, that would mean at least 1,000 more people a week that didn't need to use MIQ, so 1,000 more beds available in MIQ per week that the government could use to look at other border exceptions. However, the latest news is that a bubble by Christmas is just no longer possible as much as people want it to take place. And the current word is that if one does occur, it won't be till at least February. The issue is the difference of approaches that we take as countries to infections in the wild. So in Australia, or at least some of the states, less than 30 infections in the wild in over 3 days is acceptable and won't trigger a lockdown. Where in New Zealand we had the one case a few weeks ago when the government basically straight away said, everybody in Auckland work from home tomorrow if you can. The city was a ghost town, there was a mass number of testing done, and that was a response to one infection. So the Australian approach just doesn't fit with the New Zealand approach of trying to eradicate and keep the virus out. Of course, there are some states like Western Australia that haven't seen an infection in the wild for 7 months, but as a country, the New Zealand government just isn't yet confident that they can keep New Zealand safe if we have a bubble with Australia. So that is why we are expecting to see a further border exception added for the next 2 to 3 months, unless there is a major increase in MIQ, or the government starts allowing other providers of MIQ, such as education providers, who have been asking but have so far been denied by the government to do that. We will let you know if anything does develop along those lines, because that is going to make a number of changes to a lot of you who want to come to the country. But that is it for today's update. We're still waiting for the long delayed skilled migrant category policy changes. We hope they come through before Christmas, just to give some people some peace of mind and time to prepare your application, get things in place for the draws starting hopefully in April. We'll be back with a new video on next Saturday, the 19th of December. I'll have a guest with me who is very special to me, and we'll post a new video before then if there are any changes with immigration in the meantime. Is there anything else you want us to cover in a future video? Any questions you've got, please let us know. As always, please, if this video was helpful, please click on that like button. If you want to subscribe and hear about future videos, definitely click the subscribe button. And for all those new subscribers in the last few weeks, it's great to have you with us. Hopefully this has been just as useful as the last one. Now, as always, kia kaha, stay safe, and very importantly, stay sane. This is a hard time, and we've talked to a number of you, and we know the stress and the pain you're going through. So just try and, where possible, be happy, do what you can to stay happy. Things will get better. You know, let's be thankful that this year that is 2020, this mess is almost over, and we're going to look forward to hopefully a much better 2021.